Okay, we'll get 102 now, so we'll get started. I want to thank everybody for coming. We have a wide range of people that registered for this webinar, a lot wider than I expected, but I'm happy to be surprised. Everything from some high-tech companies to some trucking company, motel, therapeutic equestrian businesses. So that should be hopefully lead to interesting conversation. Again, thank you for being here. This is the first of 4 webinars that we'll be doing with the U.S. Patent and Trademark Office. Today's topic, Intellectual Property 101, is presented by Elizabeth Doherty. I hope I said your name right. I've heard that name pronounced a couple different ways. As the Eastern Regional Outreach Director for the U.S. Patent and Trademark Office, Elizabeth carries out the strategic direction of the Undersecretary of Commerce for Intellectual Property and Director of USPTO, and is responsible for leading the USPTO's East Coast stakeholder engagement. Focusing on the region and actively engaging with the community, Ms. Doherty ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. So at this point, I'd like to welcome Elizabeth and hand the microphone over to you. Thank you.
Thank you, Jason, and thank you to you and Christine and the New Hampshire Small Business Development Center for having the U.S. Patent and Trademark Office on with you today. And yes, you said my name correctly. I am Elizabeth Doherty, and I currently serve as the USPTO's Eastern Regional Outreach Director. And while Jason shared a bit of my bio with you, really what we like to say is the Eastern Regional Outreach Office is just a very long way of saying my team and I are here to help you. We are here to kick off this series. As Jason said, it's a 4-part series and something which we are excited to share with the residents of New Hampshire, the importance and role of intellectual property. I'm a 30-year veteran of the U.S. Patent and Trademark Office, having started the beginning of my career as a U.S. patent examiner, examining patent applications every day of the week for incredible and new and exciting technologies. My team and I now, as Jason said, work with the 17 states of the East Coast, from Maine to Florida, and including the District of Columbia and Puerto Rico. Today, we are joining together to do Intellectual Property 101, to really lay down the basics of what is intellectual property, why is it important to you, and who is the U.S. Patent and Trademark Office, and why should you get to know us? With that, I am going to share my screen. I have a number of slides to share with you today, and we will make these slides available to you. So don't feel like you have to take down every note, but certainly you're encouraged to take notes if that's helpful. My colleague Tamika Obashan is on with us today. She's going to be putting some very helpful links into the chat, and she'll also be monitoring the chat for any questions that you may have that you would like to have asked today during the program. So with that, I am going to jump into sharing my screen and putting up some slides for our use. All right, if I could just get a word that you can see the slides and that they're appearing correctly.
Looks good.
Okay, fantastic. Thank you, Jason. I appreciate it. So as I said, today we're going to spend our time together talking about intellectual property, otherwise known as IP. You may have seen it, you may have heard it, you may be familiar with the concept, but let's give you a little bit more background and information as to why it's important to you, particularly as a small business owner. What is intellectual property? As I said, what is the U.S. Patent and Trademark Office? And what are some of the resources? We're going to do just kind of a whet your appetite to some of the resources that are available to you through the U.S. Patent and Trademark Office, although the next part in our 4-part series is really going to do a deep dive on many of these resources. And I have to tell you, some of these resources are my favorite 4-letter word, F-R-E-E, free. So we want to be sure and touch on those if we have time today. So let's take a look at intellectual property from a 30,000-foot level. Really, to look at it from the importance of intellectual property to our nation as a whole, to our economy as a whole. Why is intellectual property important? IP is important because IP-intensive industries, those industries that are built upon portfolios of intellectual property, whether that's patents, trademarks, copyrights, trade secrets, or a combination thereof, they in fact create jobs. They create jobs for our economy, nearly 50 million jobs, and those are jobs which produce higher pay. So they are providing the employees of those industries with higher paid positions, which then turns that money around into our economy. These IP-intensive industries are also important because they are important to the growth and industrialization of our nation and produce 38.2% of our gross domestic product. So again, from that 30,000-foot level, why should we care about intellectual property as industries, as business owners, as people who are looking to create wealth in our economy? It's through intellectual property. It's through that protection. Why is IP strategy as a business strategy? And now this is taking it from that 30,000-foot level down to the more specific level, down to that level of you as a business owner or someone who is looking to perhaps start and build and grow a business. Why is intellectual property important? Well, intellectual property is important and attractive to investors and buyers. For any of us who have ever seen the show Shark Tank, what is one of those first questions that the sharks invariably always ask? What's your intellectual property portfolio? Do you have a patent? Do you have a trademark? That is because intellectual property can be bought, sold, licensed, given away just as real property and infuses a business with value. By protecting your intellectual property and by putting that on notice to your competitors, it can deter infringement lawsuits. By marking your products with a patent number, by using the circle with the R and letting people know that you have protected your indicator of goods and services, your trademark, you can deter others saying, listen, I've already secured an intellectual property protection for this, keep away. Or if you want to use this property, you can only do so with my permission. You can increase leveraging power. And this really goes, again, back to that making it attractive to investors and buyers. By having intellectual property in your business, it makes your business more attractive. It's a property right that can add value to a company's assets. It is part of your bottom line. Patents, trademarks, copyrights, and trade secrets to a certain extent can be bought, sold, licensed, and given away. Now, we say IP strategy is a business strategy, is global, because in fact, most of us are working on a global economy. Most of us have our product for sale, or many of us at least have our product for sale in online, which all of a sudden opens up the buying potential and the buyers around the globe. But it is a global strategy. Now, it is important to note that intellectual property is what we call territorial. It only protects you in the country which has issued you those rights. And we'll touch on this a little bit more specifically as we get further into our presentation today. So why does invention matter to you specifically? And that is looking at the form of intellectual property where we are referencing a patent. So those of you who are looking to bring a product to the marketplace to commercialize a technology, whether it's a bicycle, a new cellular communication device, or a mousetrap. Why does invention matter to you, and what can a patent bring to your business? It can promote innovation and help safeguard your inventions. Again, it puts those who are working in your competitive space of technology, it puts them on notice that you have protected your invention. It also allows an opportunity for people to know about your invention. By having an issued patent, it is published. It is a published application and then published as an issued patent. It then joins this enormous repository of technological information that is available globally, that is available worldwide. Patents help companies grow. 99% of patents that issue today are improvement patents where somebody is increasing the efficiency, the effectiveness, the operability of a device. By having a patent, you again put your information out there for others to build upon. By having patents, you can benefit the community by making new goods and services available. What are patents? Patents are solutions to problems. What are inventors? Inventors are individuals who are looking to address a problem and find a solution. So you can benefit the community by making goods and services available by addressing the challenges that face you, your family, your community. And of course, patents can also provide personal growth, development, and advancement. Now, that's both within a company or as an independent inventor. And I'll give you one simple example. My father is an inventor. He has a patent. Now, that technology was never commercialized, yet he has always been personally and professionally proud of the fact that there is a US patent with his name on it. So it was certainly an opportunity for personal and professional growth, but it also then enabled his business, the company that he was with at the time, to consider and build upon that technology. So what is intellectual property? I think a good way to look at intellectual property is to actually juxtapose it against real property. We're all very familiar with the concept of real property. It's your home, it's a car, it's a boat. It is anything that can be licensed, can be bought, can be sold, can be given away to your heirs. Real property is that tangible property that we have in our possession that we can place our hands upon, real property. Intellectual property, as the name suggests, is property of the mind. It is in fact creative property, property that was developed through an intellectual process, whether by you as the sole owner or you and a team in developing some type of creative answer to a problem, creative solution. It is, again, the property of the mind. Now, like real property, it can be bought, it can be sold, it can be licensed, it can be given away. So again, very similar to the concept of real property. So who is the U.S. Patent and Trademark Office? Well, we are in fact one of the oldest government agencies in the United States. Our work began in 1790 with the issuance of the first Patent Act. And in fact, we issued the first patent in 1790, the method of making potash. So the USPTO today, you see a photograph here of our lovely headquarters in Alexandria, Virginia, which is where my team and I are located. We are a 13,000 person government agency. We have regional offices in Detroit, Denver, Dallas, and San Jose. And we have nearly 8,500 patent examiners, scientists, and engineers reviewing patent applications every day of the week for a wide variety of technologies. We have over 600 trademark attorneys who are receiving and reviewing trademark applications to issue federally registered trademark registrations. So again, as our name suggests, we are responsible as America's innovation agency for issuing US patents and federally registering US trademarks. Copyrights are handled by the US Copyright Office, which is a part of the Library of Congress, and trade secrets are protected generally by contract law between an employer and an employee or by the Uniform Trade Secrets Act. So the US Patent and Trademark Office, again, protects patents and trademarks, although we also lead the administration on developing copyright policy. As I said, we are USPTO, we are America's innovation agency, and we are committed to helping inventors, innovators, and entrepreneurs to be able to bring their technologies, to bring their businesses forward to commercialization, to help protect their intellectual property. And we do so by creating a reliable, predictable, and high-quality intellectual property system. This is, again, just kind of a snapshot of what we were just speaking about. Patents, just for your information, we have over 650,000 patent applications filed every year and nearly that same amount of trademarks. Just to kind of put it into context for you, like what is the scope of the world of patents and trademarks? As you can see from this chart, we issued our first patent in 1790, and next week, in fact, we'll issue patent number 11 million. We issue patents on Tuesdays, so next Tuesday, May 11th, we will issue patent number 11 million. You heard it here first. Now you can tell from this chart, it looks like we issued patent number 1 in 1836, and you may be thinking to yourself, but Elizabeth, you said we started issuing patents in 1790. Well, we did. And in fact, we started issuing patents in 1790 because, in fact, intellectual property is written into the US Constitution. It was the founding fathers of our country who knew that in order to grow a strong and industrialized nation, we needed to protect the rights of authors and inventors, to protect their discoveries, to protect their writings. So intellectual property is written into the Constitution and was written into the first Patent Act of 1790. Now, from 1790 to 1836, we did not number patents. They were listed by the inventor's name and by the technology that they invented. It was only in 1836 with the Patent Act of 1836 that we began to number patents. So just a little curious point of history for you today. So today we're going to touch on the 4 basic types of intellectual property: patents, trademarks, copyrights, and trade secrets. And what would I like for you to remember today? Well, for starters, I'd like for you to remember the U.S. Patent and Trademark Office, but I'd like for you to remember that there are 4 basic forms of intellectual property, and that these 4 basic forms protect 4 very different things, and they protect them for 4 very different durations. So again, 4 basic types of intellectual property, they protect 4 very different things, and they are for 4 different durations. And when I say durations, I mean the length of protection. Patents protect any new and inventive ideas. As you can see here, it looks like we have some solar cells, and we also have a fuel cell technology for a car. Patents can cover a wide variety, and we're going to do a deep dive on each of these forms of intellectual property. Trademarks are the identifier of the origin of goods and services. So keep that in the back of your mind as we talk about trademarks, because while many of you may have something that can be protected by a patent, perhaps you're commercializing or bringing a technology to the marketplace, all of you, if not nearly all of you, will have something that can be protected by a trademark. Whether you're opening a nail salon or bringing a new bike to the marketplace, you probably have something to protect with a trademark. Copyrights, again, through the Library of Congress, the U.S. Copyright Office, they are a creative expression stored in a tangible form. We're going to talk more specifically. There is a level of creativity necessary. There must be an expression, and that expression must be stored in a tangible form. Trade secrets, any information that is valuable and can be kept confidential. So what's important here is information that is valuable to the business or to the owner of that information, and that may be kept confidential. Once the secret is out, you no longer have a trade secret. This chart is really just a further deeper dive on the chart that we just looked at. Now you may say to yourself, but you said there was 4 basic types of intellectual property, but yet I see 6 here in this chart. Well, what we've done here is we have broken down the fact that there are 3 types of patents. There are utility patents, design patents, plant patents, and then of course there are copyrights, trade secrets, and trademarks that we just touched on. The 3 different types of patents protect 3 very different things, and they also have different durations. Very quickly, a utility patent protects what we generally think of as an invention. Again, whether it's a new toothbrush, a new cell phone, or a new computer, it is protected in large part by a utility patent or multiple patents. In fact, it was once said, and I can't speak to the veracity of this, but it was once said that there are over 75,000 patented inventions in your iPhone. Again, I've never been able to find any evidence of that, but there's easily multiple patents in any cell phone, whether it's an iPhone or not. Utility patents are good for 20 years from the date of filing in the United States. Design patents protect the ornamental design for an article of manufacture, and oftentimes inventors will seek both types of intellectual property protection, utility and design, on a particular invention. Again, going back to the iPhone, there's a perfect example. There are utility patents which protect all of the operating features of that device, whether it's the transistors inside, the speakers, the camera, the various things that make up that phone. It is also protected by design patents. The ornamental appearance of that phone is protected by a design patent. Design patents are good for 15 years from the grant of a patent in the United States. So again, recognize the distinction. Both are valuable forms of intellectual property protection and oftentimes can be part of the same intellectual property portfolio. Plant patents protect any newly invented strains of asexually reproduced flowering plants, trees, or other hybrid plants, good for 20 years from the date of filing. Copyrights, as we said, are original works of authorship, having a certain level of creativity, including literary, dramatic, musical, and artistic works. They are good for the life of the author plus 70 years. So they have an incredibly long duration. So both the creator has the opportunity to enjoy the benefit of their creation and their heirs. Trade secrets, incredibly valuable form of intellectual property because they can potentially last forever as long as the information remains confidential and functions as a trade secret. And there's a wide variety: formulas, methods, devices, compilations of information. Trademarks, last but not least, are words, symbols, logos, designs, or slogans that identify and distinguish the source of products or services. Trademarks, like trade secrets, are incredibly valuable because they too can last forever if they are continually used in commerce and they are continually renewed with the U.S. Patent and Trademark Office. And those renewals come up at every 10 years. So let's talk about each one of these a little bit more specifically. Trade secrets, as we know, protect anything that brings value to a business that may be maintained as a secret. And here's two great real-world examples. That recipe for KFC chicken, what makes that chicken so delicious? Well, I can tell you, I sure don't know. I have no access to the Colonel's special recipe. And then, of course, there's the Google search algorithm. How is it that by typing in a few keywords, Google is able to return the search results that they do in response to your keywords? Well, their algorithm is one of their best kept trade secrets. So when talking about a trade secret, as we've said, there are many things that can constitute a trade secret: a recipe, an algorithm, a method of doing business, a customer list, in fact. What is important is maintaining that confidentiality. And how does one do that? Well, again, oftentimes it is through contract law between an employer and an employee. However, failure to take those adequate steps to prevent disclosure, whether it's through a contract employment or maintaining the secrecy of where that information is kept, can cause someone to lose a trade secret. Anecdotally, there are stories told of where perhaps there is a recipe that's kept secret. Maybe the recipe, all of the steps or ingredients of the recipe are not known to one employee, but they're in fact distributed amongst numerous employees. So if you fail to keep your trade secret, it can happen by a number of ways, one of which is failure to take adequate steps. You don't keep the recipe locked up. You don't distribute it amongst employees. Owner or owner authorized disclosure. Oftentimes it's determined that this disclosure is necessary, and that can in fact invalidate that trade secret. Reverse engineering, of course, happens where someone can independently develop that technology by seeing your technology and then reverse engineering it by, in fact, building it back. I once had a conversation with some university students who invented a unique mechanical device, but it was a relatively simple mechanical device, and they were considering protecting it by trade secret. I counseled them that perhaps this was not the best idea because one could readily look at the operation of this simple mechanical device and figure out exactly how it operated, exactly how it was engineered, and could have in fact themselves. So reverse engineering is one where you'll frequently see the loss of a trade secret. Let's talk about copyrights next. Again, doing a deeper dive on each one of these four basic forms of intellectual property. As I said, copyrights are administered by the U.S. Copyright Office, the USCO, which is part of the Library of Congress, and they protect original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works. Author's life plus 70 years, and I encourage you to check them out at copyright.gov. Copyrights are a unique form of intellectual property because each and every one of us already is in the ownership of copyrights. Copyrights are what we call self-authenticating. By merely placing that original work of authorship in a fixed medium, you have in fact obtained a copyright for your work. However, by registering your copyrighted work with the Library of Congress, you avail yourself of additional protections for your copyrighted work. So if any of us have ever written a letter, or we've written a poem, we've written a term paper, we've created a piece of art by painting, by sculpture, by even creating a doodle on a piece of paper while in the middle of a meeting that maybe we got distracted from. Again, it requires that there be a certain level of creativity. So you might say to yourself, well, gosh, I just wrote down a grocery list today. Is that an original work of authorship placed in a fixed medium? Well, yes, you are an author, and you did place something in a fixed medium if you wrote that grocery list on a slip of paper with a pen. However, is there the requisite level of creativity to create a copyrighted work? And the likelihood is probably not. Now, if on that same grocery list you did some doodle artwork, would that rise to the level of a copyrighted work? Perhaps. Or if next to the list of grocery ingredients, you wrote down a recipe that you just came up with on your own that you were going to try and make with all of these wonderful ingredients, would that be something that is a copyrightable work? Perhaps. Again, a level of creativity being added to just that list of ingredients. So as we've said, things protected by copyrights can include a wide variety of things: songs, books, movies, sculptures. So let's talk about trademarks. And again, trademarks are incredibly valuable because nearly every business endeavor has something protected by a trademark. And in fact, in likelihood, many trademarks. We think about McDonald's as one example. Certainly the name McDonald's is a well-held trademark in that company. The Golden Arches is another trademark. The name Big Mac, the name Quarter Pounder with Cheese, perhaps. Certainly Ronald McDonald, all trademarks of the McDonald's franchise. So what can serve as a trademark? Any word, slogan, symbol, design, or combination of these that do two things: identify the source of your goods or services, and in the same breath, distinguish them from the goods and services of another party. If somebody, using our McDonald's example, if somebody was to say to you, hey, would you like to meet up for a Big Mac today? You wouldn't go and park yourself at the Burger King and wait for your friend to arrive, because you knew they were talking about a hamburger that has 2 all-beef patties, special sauce, lettuce, pickles on a sesame seed bun. And you know that you can only get a Big Mac from McDonald's. So it identifies the source of the goods, in that instance, the goods being a hamburger, and it distinguishes them from the goods and services of another party. So you know that that Big Mac cannot be obtained from Burger King. Now, if your friend said to you, hey, would you like to meet up and have a Whopper for lunch today? You would have in all likelihood have met them at the Burger King parking lot. So again, identifies the source of goods or services and distinguishes them from the goods and services of another. And this is important as a business owner, because you want to let people know of the products that you are providing, the products and services, and also to distinguish them because you want them to come back to you time and time again. Trademarks can be words, they can be designs or combinations thereof. And here's a couple of great examples: Starbucks, Nike, Target. There are also things called non-traditional marks. And while there's fewer of these types of trademarks, they can also provide great value in, again, identifying the source of goods and services. How many of us have heard, what can Brown do for you? We immediately have UPS come to mind. Or when that brown truck drives up your driveway, you don't think to yourself, oh, look, the FedEx driver's here. We have all come to recognize that brown truck as being associated with the United Parcel Service, UPS. John Deere green, robin's egg blue for Tiffany's. There are also some non-traditional marks, though very few of them, that are scent marks, where that scent is so distinctive, it can identify the source of goods and services. For any of us who have ever opened a can of Play-Doh, oh, you know that smell anywhere, wouldn't you? You would know that you have just opened that children's play creative dough craft product. There are also sound non-traditional marks, which when you hear that sound, you again are very firmly associated with the producer of the goods and services. The Pillsbury Doughboy, his giggle, characteristic giggle that we would all recognize anywhere. The NBC chimes. When our trademark attorneys pick up your trademark application, your request to federally register a trademark, how is it they determine whether or not to issue you a federally registered trademark? Well, it's through an analysis of a likelihood of confusion. And this is really a two-part test. They will look to see, are the marks confusingly similar? So they will take your application for a trademark and compare it against others. Are there other marks already registered that sound alike, that look alike, that have similar meanings? Is there going to be any confusion for the consumer in seeing these marks? They're then going to analyze the second prong of the test. If there are any marks that look alike, sound alike, have similar meanings, or create similar commercial impressions, are the goods and services related? Are they encountered in the same channels of trade? And I'll give you a great example to kind of elucidate this concept. Think about Delta Faucets and Delta Airlines. Do they look alike? Well, in fact, the words look alike, yes. Do the images look alike? No, they each have a very distinctive design mark. But do they sound alike? Yes. Do they have similar meanings? Delta, well, while there is the word Delta in the dictionary, and Delta does have several meanings, dictionary meanings, that's not the meaning for the airlines or the faucets. But so in the instance of Delta, the marks do on their face have a confusingly similar sound and perhaps impression for the average consumer. However, are those goods and services related? Are they in the same channels of trade? And the answer is no. If you were to walk into your local hardware store and see Delta faucets on the shelf in the hardware section, you would not be confused that the commercial airline service has now begun producing faucets. Nor if you went to the airport and you waited in line to purchase your ticket for a Delta flight, would you scratch your head and say, when did the hardware service start selling airline tickets? They are not the same channels of trade, and thus we are able to issue federal registrations for two businesses having the same trademark. And when I say the same, they appear the same textually, DELTA, and they sound alike. Yet, however, their design image are very different, and again, they represent very different channels of trade. So again, trademarks are fascinating, and trademarks can be incredibly valuable to a business, because this is how you build brand loyalty. This is how you build up the recognition of your brand and people wanting to participate and return to your brand time and time again. Think about it when you visit the cereal aisle of your local grocery store. There are so many choices in that cereal aisle. What helps you to select that cereal that you know and love? You have come to recognize a brand name, and you have come to recognize the product name, both of which in all likelihood are protected by a trademark. Let's talk about patents. So, and I will point out that in this 4-part series that we're doing, 2 of the sessions are going to do deeper dives on patents and trademarks. So we'll be sure to have lots of time during those separate presentations to focus on deeper dive questions about patents and trademarks. Today, we're just really kind of scratching the surface to provide some basic information as to what the 4 basic types of intellectual property are: patents and trademarks, copyrights and trade secrets. Hopefully with you're being able to walk away appreciating what an intellectual property portfolio could hold and why that might be important to you in your particular business endeavor. So what is a patent? The patent is the right to exclude others from making, using, selling, offering for sale, or importing your claimed invention without your permission. As the patent owner, you have that right to exclude others from doing all of those things without your permission. It is for a limited period of time, just as copyrights and trademarks. That limited term being for utility patents, as we touched on, 20 years from the date of filing; design patents, 15 years from the date of issuance. Patents are territorial, just like every other form of intellectual property, and provide you with protection only in the country which issues you that right. Types of patents, and we touched on this earlier, there are utility, design, and plant. So important to know that these 3 types of patents protect 3 very different things, but oftentimes can be found in an intellectual property portfolio covering the same invention. For those of you who have never seen a patent, I just want to give you a quick screenshot here. Patents require a great deal of information. So when you begin down the path of filing a US patent application, You have to describe your invention with such specificity that others can make and use your invention. Thus, there's a specific format for your patent application and ultimately what issues as your US patent. Your invention has to have a title. It has to have information about the prior art that you disclosed as well as that was found by the US Patent Examiner. If your invention can be depicted in drawings, you have to include drawings. You have to have an abstract and you have to have a specification. Claims are perhaps the most valuable part of your patent, and certainly what people are going to look at most quickly when trying to ascertain the metes and bounds of your invention. That's what really, like your deed of real property, which tells you where your driveway starts and stops and where you can put a fence, the claims of your patent are going to let people know the exact parameters of what you have invented. Now, in order to be eligible for protection by patent, it has to fall into what we call statutory classes of invention. It has to be a process, a machine, a manufacture, a composition of matter, or any improvement thereof. Hurdles to patenting include one, does it also fall into that statutory subject matter that I just touched on? Your invention also has to be novel, meaning that it is new and not previously known to this world. And when I say this world, I mean even outside of the US, because our patent examiners are such talented searchers. They are going to look the world over when reviewing your patent application. They are going to review the world over for any technology that is pertinent to the patentability of your invention. They're going to look at US patents, US patent applications, but they're also going to look at foreign patents. They're going to look at trade publications, trade journals, senior thesis documents, anything that is published and publicly available that is pertinent to whether or not your invention is new. Your invention also has to be non-obvious, meaning the differences between your invention and the prior art would not just be an obvious variation. So if you've invented a new toothbrush, they are going to make sure that it is not an obvious variation upon an existing toothbrush or an obvious combination of existing toothbrushes. And as I said, does it have utility? Does it function as intended? And that's a relatively low barrier of entry. Take, for example, a baseball hat. Does a baseball hat have a utility? Well, of course it does. It protects your head from the sun. It can keep your head dry from the rain. So it has a utility and does have a functioning purpose. What cannot be patented? Well, one cannot patent a mere idea. Now, this does not mean that you have to have a working prototype in order to file a US patent application. One must just be in possession of the invention, however, that invention can be developed into a new, non-obvious, useful machine, manufacture, process, or composition of matter that can actually accomplish the task. I'll give you a simple example here. And my idea is that I would love to invent a time machine. I would love to have a time machine where I could go back in time and meet fascinating people like Harriet Tubman and Abraham Lincoln. Now, do I have an invention? I do not. I have an idea. Can I patent my idea for a time machine? I cannot, because I cannot describe it with such specificity in a patent application that others can make and use my invention. You cannot patent natural phenomenon, and you cannot patent abstract ideas. The path to a patent is a multi-step process, beginning, of course, with your idea, but again, it must be more than a mere idea. It may involve filing a provisional patent application. A provisional patent application is a one-year placeholder that you can file with the office with a low barrier to entry, low financial barrier, and low submission barrier. But that is not examined. That cannot result in a US patent. It's only when you file that non-provisional patent application that you have something picked up by a US patent examiner and that can result in a patent. As I said, and again, we're going to provide these slides to you, there are many differences between the provisional patent application and the non-provisional. I oftentimes hear people say, oh, I have a provisional patent. Let's be clear, there is no such thing as a provisional patent. You may have a provisional patent application, which again is that one-year placeholder with the US Patent and Trademark Office that can form the basis for a non-provisional, which is then examined and results in a patent. Important to know, and they're both extremely useful tools. Only the non-provisional can result in a U.S. patent. This slide, which certainly looks as an interesting highway to be on, and it is the path to a patent. The point of this slide is really to let you know that the patent application process is a process of communication and collaboration with the office. We want to arrive at the same result that you do, and that is issuing you a valid U.S. patent that you can take to the bank and not to the courthouse. So it is a process of communication and collaboration that may involve rejections or objections and amendments and arguments, but we see ourselves as two sides of the same coin, working together in this process. I want to just touch very quickly on some of the resources that, again, we'll do a much deeper dive in our next presentation, but want to just start to whet your appetite and to help perhaps get you started in visiting our website and looking into some of the things that we have available to help you as an inventor, innovator, and entrepreneur. First and foremost, I encourage everyone to visit our website, uspto.gov. And when going there, it is rich with information. So where to get started? I always love to send people to the Learning and Resources pull-down tab, which is a great entrance for educators, inventors, entrepreneurs, startups, kids, and teachers, because that's where we really lay out for you some of the basics and some of the how to best get started in the process. I would also encourage you to go to the Finding Direct Resources in your geographic area, and we're going to touch on that here very shortly. We also have Inspiring Stories, a COVID Response Resource Center, and a toolkit on demystifying the patent system, which again is a great place to get started. As I mentioned, my team and I are located at the USPTO office headquarters, which is in Alexandria, Virginia, but we have regional offices in Detroit, Denver, Dallas, and San Jose. We're all currently teleworking, as many of you are, but we hope to be back in the offices sometime in the hopefully not too distant future. We do love for you to visit us at our sites and are there to help you. And certainly we can help you virtually right now as well. Here's another beautiful view of our Alexandria headquarters campus. Should you ever find yourself in Alexandria, Virginia, which is directly outside of the District of Columbia. On our campus, we also have the National Inventors Hall of Fame Museum, which is a delightful museum recognizing over 500 inventors who have truly changed our world through one or multiple patents. Finding help in your area. This is a great place to start. And I've given an example of the New Hampshire page that you'll find in the Finding Help in Your Area. Now, of course, there's a page for each of the 50 states as well as Puerto Rico. So should you find yourself somewhere outside of New Hampshire, you're also welcome to visit one of those pages too. When you visit the New Hampshire page of our webpage, you will find there information on free patent and trademark legal assistance. Namely, for New Hampshire, they participate in the New England Pro Bono program. And there is also the University of New Hampshire Franklin Pierce School of Law, which has a trademark law school clinic. And I'll talk a little bit more about those in just a second. We also have a Patent and Trademark Resource Center at the University of New Hampshire Franklin Pierce School of Law Library, where there is a librarian who is well-versed in patent and trademark searching, able to help you in conducting a patent and trademark search. You can also find information about networking with inventors and entrepreneurs and organizations in your state. And I would call to your attention an organization called the New England Inventors Association. While they meet in Massachusetts, they do reach out and offer assistance throughout the New England area. For those of you who are visual learners and love to learn through a good video, I encourage you to visit our USPTO YouTube channel, where we have a number of pre-recorded programs, some of which are from previous events, and some of which were recorded just to be placed in our video library. We also have a wide number of subscriptions that you can sign up for, where you get information dropped into your inbox when we have something to share with you. Again, there's 12. You can sign up for one or all of them, and they provide a wide variety of information with respect to patents, trademarks, copyrights, things that are going on in the office, as well as training opportunities like what we're doing today. Our events page is another place that I strongly encourage people to visit, and that is also under the Learning and Resources pull-down tab. When you go to our event page listing, you'll see that every given day of the week, Monday through Friday, we have multiple trainings taking place on a wide variety of topics, from patents to trademarks, copyrights, to artificial intelligence, protecting your IP in China. You name it, we teach it. These are all free webinars, and you're welcome to sign up for as many as you like. Our Startup Resources page, which is also available from the Learning and Resources pull-down tab, provides, again, a great one-stop shop for getting started. Patents for startups, trademarks for startups, startup assistance, and current events. That takes you back to the event page I just shared with you. This is a great place to start getting your feet wet to understanding what the patent process looks like, the trademark process, and things you should be considering as you start and build and grow a business. We also have our Inventors Assistance Center, our IAC, which is staffed Monday through Friday, 8:30 to 8, and they are there to take your calls and emails. They love to help, and these are retired individuals who have worked 30 or 40-year careers at the U.S. Patent and Trademark Office and are gifted in assisting inventors with any question, whether it's prior to filing an application, during prosecution of your application, or after your patent has issued. We similarly have a Trademark Assistance Center, which also provides a great deal of information and assistance to those of you who are pursuing a federally registered trademark. Our Patent Pro Bono program, and again, this is going to be talked about in a much greater depth, is a program that we are extremely proud of. It's a result of the 2011 America Invents Act. We now have state and regional pro bono programs that are helping under-resourced inventors to not leave inventions on the kitchen table or on the garage workbench because they are financially under-resourced. These programs help inventors, and again, they welcome your call. Because these resources are somewhat limited, though, there are requirements for participation, and you can see them listed here on this slide. As I said, these programs are state or regional programs and cover the entirety of the 50 states. The corollary to that, to the Patent Pro Bono program, is the Law School Clinic Certification Program. And we have many law schools participating across the country where students, under the supervision of a registered practitioner are allowed to work on patent and trademark matters. As I mentioned, the University of New Hampshire Franklin Pierce School of Law has a trademark clinic where they can help under-resourced individuals pursue federally protecting a trademark. As I said, the Patent and Trademark Resource Center is located also at the University of New Hampshire Franklin Pierce School of Law and has a librarian who is gifted in patent and trademark searching. Now, you may ask yourself, do I have to conduct a patent or trademark search? And the answer is no. There is no requirement by law that you conduct a patent or trademark search prior to filing for a patent or trademark. However, as I like to say, why not save yourself the headache, heartache, and financial outlay, because someone may have had your idea. Your idea is just so great that someone may have had your idea. Why not learn that before you file your patent or trademark? Now, of course, when you file your patent or trademark application, the patent examiner or the trademark attorney is going to do a thorough search. That is part of the work that we do. But again, I think it's, again, a valuable thing to do prior to filing. And also, it's very helpful to know what else is out there in your field of endeavor, to see what your competitors are doing, because perhaps your technology can be a refinement or be an improvement upon something that's previously been done. With that, I want to be sure and leave you with my contact information. And I am going to stop screen sharing because I want to be sure and allow time for questions.